This is Duke University.
Go ahead and get started. I know people are still coming in, but want to leave some time for question and answer at the end, so we're going to go ahead and get started. Thank you all for coming today to this panel discussion of Fisher versus University of Texas at Austin and the future of race-conscious admissions policies generally. On behalf of the American Constitution Society, I'd like to thank Duke Law ACLU and the Program in Public Law for co-sponsoring the event today. Both of our panelists are members of the Duke Law faculty, so I won't waste too much time with introductions. I know they're both familiar to all of you. But before we get started with them, Chris is going to sort of tee up the case for us, give us some facts on Fisher versus University of Texas, and tell us what the question presented to the court was. So, hand it over to Chris.
Again, thank you all for coming. For those of you standing in the back, it looks like there are some chairs down here in the front. There's one over on the side, maybe two in this row if you don't want to stand back there for the next hour. But this case comes down to affirmative action in the use of admissions processes for these different universities. And the first time the Supreme Court takes a crack at the way we admit students to our universities is in 1978 in the Regents of University of California v. Back. And in this case, the Supreme Court decides that a hard quota is unconstitutional. The medical school at UC Davis had reserved 16 seats out of a class of 100 for only underrepresented students, and it was unconstitutional to deny white students access to those seats. Then we fast forward to 2003, and there are two cases decided simultaneously. It's Gratz v. Bollinger v. Grutter, and Grutter v. Bollinger. So in Gratz, this is a 6-3 decision reaffirming the court's position against the quota system. It's at the University of Michigan, and the undergraduate admissions process used a 150-point scale ranking applicants, and you need 100 points to ensure admission. The university would provide underrepresented students with an automatic 20-point bump. And what would end up happening, to put that 20 points in comparison, if you had a perfect SAT score, it was only worth 12 points. So this was like a very significant bump. The Supreme Court, in a 6-3 decision, decides that that is a quota. It is the predetermined point allocations is unconstitutional. Now in Grutter, it's a 5-4 decision the other way as it applied to the University of Michigan Law School. What the court decides here is that the school's race-conscious admissions process that may favor underrepresented minority groups was constitutional because it only took into account many other factors evaluated on the individual basis for every applicant. The university argued that diversity, ensuring a critical mass of students from minority groups to ensure that these minority students did not feel isolated or like a spokesperson for their race, also provided educational benefits. The court here, and just as an outline, when the court is looking at all of these different admissions processes, they're using a standard of strict scrutiny, which means that the school needs to justify its policy, that it has that the school has a compelling interest for that policy, and that additionally it's tailored in the most narrow way possible. And the court decides that the University of Michigan Law School's process met all of those requirements. So now we fast forward to Fisher v. University of Texas. The 2012 oral argument was in October. The question presented is whether the University of Texas at Austin's use of race in undergraduate admission decisions is lawful under the court's decisions interpreting the equal protection of the 14th Amendment, including Grutter v. Bollinger. This case is particularly interesting because Texas uses a system of admission for this school that if you graduate in the top 10% of any high school in Texas, you're automatically admitted to the school. That accounts for 75% of the incoming student body. The additional 25% that fills out the class is then used with a more or less traditional method of figuring out applicants, weighing, among other things, race, but it's also your academic profile and your personal achievement index. The personal achievement index is 2 written essays, a personal achievement score, which includes special circumstances, some of which are race. The University of Texas describes its consideration of race as a factor of a factor of a factor of a factor, and then it's not given substantial weight. So Fisher is Abigail Fisher, a white student who in 2008 was denied admission to the school. She was not in that 10% category, so she's arguing for this 25% rest of the class. And they're arguing that UT is using race for the wrong reasons, that its goal is not diversity for the sake of educational benefits. The only exception, which is recognized in Grutter, they're saying that considering race as a factor and the 25% only has a minimal effect on racial composition, the system is not narrowly tailored, and the Supreme Court should either clarify or overrule Grutter. The University of Texas's arguments is that the admissions process is almost identical to the plan held constitutional in Grutter, that UT is allowed to consider race in the context of a holistic review. This is the language of Grutter, and that UT's goal is to provide the educational benefits of a richly diverse student body. What's crucial about this case is that the challenge is only to the 25% of that class, the non-10% that have automatic admission. However, the decision of that group will have repercussions for all higher education institutions. Texas law only works because the state is so segregated. Basically, you can have a representative class at this for your freshman class because the very dense African-American school districts, for example, that 10% is all mostly going to be African-American. For these Hispanic school districts, it's largely the 10% is going to be Hispanic. If you do this on a national scale, then all of those considerations are now out the window, right? Because it's not segregated enough to automatically propel underrepresented groups into the admitted class. So the last thing I'll end with here before we turn it over to our panelists is that in an article in the New York Times, they describe that diversity is the last man standing, the sole remaining legal justification for racial preferences in deciding who can study at public universities. Should the Supreme Court disavow it, the student body at the University of Texas and many other public colleges and universities would almost instantly become whiter and more Asian and less Black and Hispanic. So we'll turn it over to our panelists. Thank you.
All right, Professor Siegel and I wrestled. I won, so I get to go first. All right, first, there are some seats down here, so don't be shy. Come on down. You don't have to hold up that wall. I will quickly try to run through some markers on this case and try to do that as efficiently as possible to both leave time for the two of us to chat and as well as all of us, or as many of us, to chat as possible. So the overall question is, well, what is the court likely to do? And I have no idea what the court is likely to do, but what we can do is provide some of the issues that may factor into their decision. One way the court could think about this case is on standing grounds. That may not be the likely disposition of the case, but it certainly is an issue. And the question is, what is the injury that Abigail Fisher suffered? One option is to think of it as the injury of being subjected to a process in which race was a consideration. So race as categorization problem. So equal treatment is the way that her lawyers are putting it. Another way of thinking about it is that, look, she didn't suffer any injury because she wouldn't have been admitted to the school given, no matter what, whether there was a racial categorization or not, she wouldn't have been admitted, and so there was no injury. In fact, there are no damages, and therefore she doesn't have standing to bring this claim. That may not be a likely disposition, but it's certainly in the minds of the liberal justices in particular. All right, the other question, as in many of these types of cases, is what is Justice Kennedy likely to do? All right, that is the $1 trillion question. It's a good thing the election did not come down to that. And so what is Justice Kennedy likely to do? Again, it's unclear, but certainly Justice Kennedy is not Justice Scalia and is not Justice Thomas, and may not even be the same as Chief Justice Roberts. Justice Kennedy has at least a theoretically nuanced view on race. He certainly believes that racial categorization and race consciousness, that diversity can be a compelling interest, certainly if narrowly tailored and under certain circumscribed circumstances. He has certainly talked about folks of color in a way that reflects a certain amount of solicitude for the plight of racial inequality. So as a theoretical matter, Justice Kennedy is committed to the diversity rationale. As a practical matter, it may be that this is in theory only, but never in practice. All right, sort of like, look, if you bring me a program that is very, very narrowly tailored, where there's a very compelling interest, at least in the higher education context, or elementary school context, I will approve it. I just haven't seen one yet. Right, that could be the possibility that we see with Justice Kennedy. Clearly, at least I'm curious to hear what Neil thinks about this, if he wants to opine on it. It seems to me that if there is a program that uses race in a limited way, that categorizes race in a limited way, it is the UT program. And in fact, at oral argument, Justice Sotomayor was pushing the plaintiff's attorneys on this point, which is to say, and Justice Kennedy in particular brought this point up, which is to say, look, if this is a limited use of race, then really what is the harm? All right, if race is a subcategory of a subcategory of a subcategory, then what is the harm if race is being used in this context? So it might be the case that this is something that Justice Kennedy picks up on. All right, two remaining points before I stop. One question. Did you want to intervene? No. Okay. One question. He lost. See, that's what happened when you lose a wrestling match with me. You don't want to intervene, do you? One question is, my good friend, is what is the relationship from a constitutional perspective between the 10% plan and the affirmative action plan? All right, the use of race in Texas. So you see, particularly at the oral argument, where Justice Ginsburg was essentially making 2 points. One is, look, the 10% plan stands alone. It is constitutional under Grutter. It stands alone. And you don't need to consider it in the context of, so not the 10% plan, the racial categorization plan, the affirmative action plan stands alone, and you don't need to consider it in light of the 10% plan. And so those two things are unrelated, and it stands alone in of itself. And of course, the plaintiff's making the argument on the other side, which is, look, in light of race-neutral alternatives, as exemplified by the 10% plan, the affirmative action plan is going above and beyond the 10% plan. It's a use of race. It's not compelling, and it isn't narrowly tailored. And so from the plaintiff's perspective, obviously, the affirmative action plan has to be viewed with the 10% plan. It could be that you regard the 10% plan as I can't remember what your name is, I'm sorry. Chris. All right, as Chris said, there are a couple ironies in the 10% plan. One is that it relies upon racial segregation, all right, and that is not something that many parts of the country can do. You can do it in Texas, but you may not be able to do it in other places. The second part is, and the Fifth Circuit opinion brings this out a little bit, which is that it pushes back against the UT's goal of having a very, very strong class, because not all schools, right, are created equal. There are some that are stronger than others, and the court particularly makes this point that you have, say, students of color at integrated schools that fall below that top 10%, that are stronger, that may not be admitted, or that are going to be admitted, obviously, under the top 10% plan, that are stronger than both white students and students of color admitted under the 10% plan, right? So if you're UT and what you're trying to do is to bring a strong academic class together, the goal of bringing a strong academic class together, as well as the goal of trying not to bring a segregated class at UT, using the 10% plan, pushes against one another, because the 10% plan, you have some students that are very, very strong and may in fact be stronger than the ones that you're admitting, but you can't admit them because of the 10% plan, under which you admit about 80% of your class, right? So there's an irony with respect to the 10% plan that I think, but certainly Judge Higginbotham in the Fifth Circuit was sensitive to, and some of the justices in the court at oral argument seemed to be sensitive to. All right, one last point. Listening to the oral arguments on this case, it was really interesting how strong Justice Sotomayor, the forceful of a role she played, it seemed to me, at oral argument. And so it's been a long time since you've had a person of color on the court who was also nominally in favor of affirmative action, who could serve as both a symbolic and rhetorical counterweight to a majority opinion that would go after something like affirmative action. And so Justice Sotomayor can speak to this issue with, I think, an interesting racial credibility. That is, in the similar way that Thurgood Marshall used to call out on race grounds the court's moves when the court attempted to limit racial opportunity. There's a way in which Justice Sotomayor can do it that I think might cause a conservative majority, to be a little bit more reticent than it might otherwise be. Maybe that's a hope, maybe that's fact, it's not clear, but it was interesting listening to her at oral argument. First of all, she's no wallflower, right? But secondly, she brings she's willing to make a certain type of an argument that say Breyer and Ginsburg may not be able to make, or may not make quite as forcefully. So as she pushed back, for example, on critical mass in a way that I think forced the plaintiff's lawyer to be a bit more hesitant and might have an impact on the majority. All right, more to say, but I'll stop here and push it over to my great friend, Professor Siegel.
Well, thank you very much, Professor Charles, and thank you to ACS and Public Law and ACLU for sponsoring this event, and thanks to all of you. This is really a great turnout for a very important set of questions. It's really not wise to plan your retirement based on what the Supreme Court's going to do. It's particularly not wise to bet on what Tony Kennedy's going to do, how he's going to respond to the case. I didn't think I was going to do that, but I decided, I'll do it anyway. The speculation is fun, and at least in this context, it's going to be reasonably informed. Now, I should say before I get into this that Professor Charles mentioned several times the wrestling match that preceded this event. He didn't mention once that it was thumb wrestling. And he cheated. So let's remember what happened here. Chris, I thought you teed up the case very effectively. We're talking about a program that's a layer cake. You've got about 75% of the class being produced based upon this 10% plan. It's a facially race-neutral plan, but it is a definitely race-conscious plan. It's not happenstance or coincidence that after the Fifth Circuit in the Hopwood against Texas case during the 90s ended affirmative action in higher education using racial classifications, referring to Justice Powell's lonely opinion in Bakke, that Texas and Florida and California, other states that had ended racial classifications in affirmative action programs, that they came up with this 10% plan. They knew that it was parasitic on racial segregation at the high school level in the state, and they did it just because it would preserve racial and ethnic diversity without using traditional affirmative action that uses race as a plus factor, something Justice Powell approved in Bakke. So you have a race-neutral formally plan, but also a race-conscious plan. That accounts for 75% of the class, and then the rest of the class is done based on holistic review, which is the plan that the court upheld in Grutter, that Powell upheld in Bakke, using race as a plus factor, as various other considerations, various other factors like academic achievement, the strength of your essays, your particular interests or talents. Race is assimilated to other components of diversity and qualifications for entrance into the class. That's the program. The Fifth Circuit in this case upholds the program under the authority of Grutter. When the Supreme Court grants cert in this case, in my view, it's an aggressive grant. So this is not a case that's on appeal. The court doesn't have to take it. It's exercising its cert power. And it's not a typical cert grant. We're not talking about a split of authority in the federal courts of appeals or between federal courts of appeals and state Supreme Courts on an important question of federal law. We're not talking about a single federal court of appeals that struck down an important provision of federal law. So you knew the Supreme Court was going to take the health care case once the 11th Circuit struck down the minimum coverage provision. You had two independently sufficient reasons for granting cert. You had a split of authority with other circuits, and you had an invalidation of an important provision of federal law. You don't have any of that here. Grutter was only back in 2003, and there are ways in which this plan is like the Grutter plan, and there are ways in which it isn't. It's actually a pretty idiosyncratic plan. There aren't, how many states have this kind of layer cake approach? And so this is a court that granted cert because it wanted to grant cert on this case. I mean, you have four very committed race conservatives on the court: Chief Justice Roberts, Justices Scalia, Thomas, and Alito. You have Justice Kennedy, who can be characterized as a race conservative or race moderate. He's certainly a moderate compared to the other four. It only takes four to grant cert, not five. It's the only important thing the court does that you don't need a majority for. So the four race conservatives could have voted to grant without Justice Kennedy. We don't know what to make of this, but given that this is not a typical reason to grant cert, and they did it anyway, makes me think that they didn't grant cert to affirm. They granted cert to reverse. I think any time the court grants a case, it's more likely to reverse than affirm, if you look at the statistics. And in this case in particular, I don't think they took this to uphold the Fifth Circuit decision. I think they would have denied cert on very conventional grounds if that were their view. They think, at least four of them think, and maybe five, that the Fifth Circuit got it wrong and they want to reverse. Now, this is an 8-justice court. Justice Kagan is recused. And so it's possible that they could dump it on standing grounds. I won't address that, but I will include a shameless plug for my federal courts class this spring, which I invite the non-1Ls in the room to enroll in. You learn about standing doctrine, and you learn about the extent to which standing doctrine is masquerading or hiding views about the merits. And so conservatives who are very concerned about the importance of standing doctrine when you talk about the Establishment Clause or environmental laws and preventing plaintiffs from bringing suit, here are very enthusiastic about letting plaintiffs into federal court. I mean, if the injury is characterized, see, I said I wouldn't talk about it, but if the injury is characterized as the lack of opportunity to apply to a program that's not tainted by racial bias, I mean, think about how broad that is. You apply to Duke Law School with a 120 on the LSAT and a 2.0 GPA, and you have standing to sue when you don't have a remote chance of getting in the absence of an affirmative action program. So the typical views about standing ideologically are flipped in this case. More about that in federal courts.
What time does that class meet?
You're not invited. No. But on the merits, again, I think it's more likely to reverse than affirm. And it wouldn't surprise me if we saw a 4-1-3 split, with the four race conservatives writing a pretty aggressive opinion, the three liberals, Ginsburg, Breyer, Sotomayor, dissenting, and then Justice Kennedy writing an opinion for himself only, maybe a concurrence in the judgment, creating a court, 5 justices to strike down this program, but to do it on his own terms. Now, what might those terms be? Justice Kennedy is an interesting justice for reasons Professor Charles spoke about. If you want to see what he's going to do here, I think the best place to look, if you want to predict, is what he did in Parents Involved. This is Parents Involved in Community Schools versus Seattle School District Number 1. I believe it's a 2007 decision. It's within the last 5 years or so, in which the court dealt with voluntary integration plans, public school integration plans, districts, communities that are not subject to a federal court order to desegregate, but want to use race, both racial criteria that aren't racial classifications and also racial classifications to either maintain or achieve a greater degree of racial heterogeneity in their elementary and secondary schools. And in this opinion, this was a 4-1-4 split, with Justice Kennedy agreeing with neither the race conservatives nor the race liberals. And he said, on the one hand, there's a compelling interest in having school districts achieve Brown's promise of equal educational opportunity by securing the civic, social, and educational advantages of having schools of different races and ethnicities go to school together. There's a compelling interest in avoiding racial isolation, of trying to do something about overwhelmingly minority students together in racially identifiable and underperforming schools. But at the same time, he was concerned about government making matters worse, not better, if it uses race in certain ways. He was particularly concerned about racial classifications, telling individuals you can't get what you want just because of the color of your skin. And so he, on the one hand, really limited, he validated a race-conscious interest that the government has as a compelling interest, but he limited the ways in which the government could vindicate that interest. He didn't say you could never use racial classifications in assigning students to schools, but you should do it as a last resort after other kinds of race-conscious means are proven to be ineffective. He talked about it being offensive to individual dignity to type individuals by race. He was concerned about racial divisiveness, racial balkanization, in which the government increases interracial hostility as opposed to decreasing it by using racial classifications. And yet he upheld quite explicitly other kinds of race-conscious interventions. He said, use attendance zones that assign kids to schools with the race of the district in mind. Strategically cite schools or assign teachers to schools or do targeted outreach or compile racial statistics to see how the schools are doing. All race conscious, but they're general, they're indirect. He says they don't use racial classifications. That's what Justice Kennedy said in Parents Involved, and I think he moved substantially from his previous race jurisprudence. I think he moved closer to the center when Justice O'Connor was replaced by Justice Alito. What does that mean here? I think it means here that he's going to distinguish the percent plan, the 10% part of the plan, the lower part of the layer cake, which is not being challenged, is not before the court. That is race conscious, but it's formally race neutral. It doesn't use racial classifications. It's not being challenged, so I don't think the court's going to have occasion to strike it down. But I don't think he's going to raise any questions about it. In fact, he might go out of his way to validate it, to support it. This is like the race-conscious attendance zone. This is taking race into account in a general, indirect way, not individual racial classifications. When it comes to the rest of the plan, if he wants to make a statement and talk about the importance of strict scrutiny and the real concerns about using racial classifications, my guess is that he's going to strike it down. And I think he's going to strike it down not by overruling Grutter and Bakke and getting rid of affirmative action in higher education, but I think in a really narrow way, in a way that reaffirms the importance of strict scrutiny when government uses racial classifications as opposed to other forms of race consciousness, but not in a way that'll end affirmative action in higher education. He might say something like this: I'm not saying that school districts have to use that universities have to use percentage plans if they can. I'm only saying that if they choose voluntarily to use such plans, and they're available to it, and if those plans produce a substantial amount of racial ethnic diversity already, then you may not use racial classifications to increase the amount of racial and ethnic diversity by a relatively modest, maybe even trivial amount. And the numbers in this program actually bear that out. The plus factor, the holistic review, produces relatively few additional African Americans and Latinos. Now, from the standpoint of defenders of affirmative action programs, there's a bit of crazy making here. Because on the one hand, in Grutter, Kennedy dissents and says you can use racial classifications, Bakke is right, but you can't use it too much, and you're using it too much here. Whereas now, the objection may be, yeah, you're using racial classifications, but you're using it too little. It makes too little difference. So there's a damned if you do, damned if you don't quality to it. And this is a conceptual problem in the court's jurisprudence. It came up in Parents Involved as well, that I don't know how to make sense of.
And it's also conceptual in the critical mass context.
That's right.
It's a critical mass.
Well, yeah, that's right. And so I don't know what to do with that, but I think he could, and I guess will, vote to reverse and strike down this program on the narrow grounds. That the percent plan is okay, and I'm not saying you could never use racial classifications, but when you're combining it with a percent plan that's already producing a lot of diversity, that's enough. Use racial classifications as a last resort, not as a first resort. So he can reaffirm Bakke, Grutter, strict scrutiny without making it impossible for a place like Duke, which can't conceivably use percent plans. It's a private university as opposed to a flagship state university. I do think it's going to mean closer judicial review going forward from the lower federal courts about the typical affirmative action program that uses race as a plus factor. much more attention to, are you using race too much? So let me stop there, and I don't know if you want to respond to that or if we want to open it up to questions. I know we have a good 25, 27 minutes.
No, I don't I don't have any particular. I mean, I think that's exactly right. There are some conceptual difficulties in the court's affirmative action jurisprudence, including the damned if you do, too little if you don't. What's a critical mass that is not a quota? And of course, in this particular context, if Kennedy says, "Hey, you don't have to use a race neutral means like a percent plan, but if it's available, okay, well, does that mean that you can scrap it now and then just go use a race neutral means?" Well, if you can't scrap it, then does it mean that you actually have to use it? Mm-hmm. And if you then have to use it in this context, doesn't it mean that you always have to use it, right? I mean, there are a number of different conceptual difficulties, I think, in the court's affirmative action race jurisprudence that this case may, in fact, exacerbate, and I think you've nicely pointed out a number of them.
And I wonder whether some of that conceptual difficulty is intentional. I think in both Bakke and in Grutter, the court is both validating affirmative action and destabilizing affirmative action, and I think it's done for particular reasons. That this is going to be a temporary accommodation that we ought not to be altogether comfortable with, because you have a majority on the court that is committed to cultural individualism, by which they mean governments shouldn't be using race, but at the same time, a majority that recognizes the importance of government using race in some ways, to some extent, to try and deal with the social dislocations of race, all the problems that endure in American society as a result of hundreds of years of slavery and its aftermath. Bakke Powell talked about you can't use a quota, but you can pay some attention to the numbers. What do you do with that? Grutter says you can't use a quota, but you can use critical mass. What do you mean by critical mass? And one thing that's clear from the argument in Fisher is that critical mass is dead. And so the conservatives on the court were asking, in my view, not innocent questions. When Chief Justice Roberts is saying, just tell me what a critical mass means. Mm-hmm. Tell me how we know when we've got it. I just want to know how to do my job.
And not just tell me what a critical mass is. Do you have any idea what Texas thinks a critical mass is?
Right. And now the minute you answer that question with a number, what do you think happens?
You've been hit with a quota.
Right. The case is over because you just called it a quota. And so it's, on the one hand, you can take race into account, but you really can't be taking race into account. Or you can take race into account to some extent, but not enough that it makes much of a difference at all, right? So what does that mean? I think an unsympathetic reading of Kennedy and his Grutter dissent is you can take race into account as long as it doesn't really make much difference, which is not really, which maybe speaks to what Professor Charles talked about in principle or in theory versus in practice. I think he moves in parents involved. I don't think that's a fair reading of parents involved, but I think this distinction between the percentage plan and the racial classification would track almost exactly the distinction he's making in parents involved.
And the other thing that's interesting about this particular case, I mean, if you are principled about your theoretical justification that you can in fact use race, but not too much. I mean, there is, in the facts of this case, it's pretty clear that Texas is really trying, one, not to use race too much, right, sort of a categorization perspective, and then also to really be as holistic as possible, at least theoretically, all right? So they disavow and say, hey, we don't look at daily check of numbers. We're not trying to say that there has to be this many racial groups in this particular class. And diversity is open to everybody. That is, if you're a white person, you can make a diversity argument under the secondary justification, right? In the same way that if you are a person of color. All right, so to the extent that there is a case in which the state is in fact trying as best as it can, at least from a superficial perspective, to comply with the dictates of the jurisprudence, this seems to be it. So if that doesn't work for the conservatives on the court, then it tells us a lot about what the state of the doctrine really is.
Right. Well, let me push back on that, right? Because I think that argument works only to the extent you sever the holistic review, the use of race as a plus, from the percent plan. Mm-hmm. And I don't think Kennedy's likely to respond that way. He's going to say, if you look at the percent plan, I mean, these numbers, I got this out of the Fifth Circuit's opinion. Of the 363 African Americans enrolled from Texas high schools, 305 were a product of the 10% plan, 58 were a product of holistic review. Of the 1,322 total enrolled in-state Hispanic students, 1,164 were the product of the 10% plan, while 158 were the product of holistic review. And so you can say they're doing everything they can to use race the right way with respect to holistic review, but you could say that's only after using the percent plan that's generating a significant amount of racial and ethnic diversity. And so the question is, why do you need to use race as a plus at all? You did it the day after Grutter came down. And so I think really it turns on whether you view these plans together or view them separately. If it were just holistic review and they used it in this way, yeah, I think Kennedy would sign off on that. There's only one problem with that, which is, right, you'd have very few African Americans and Latino represented in this class.
Right, but
or at least you very well might.
And that's right. I mean, that is, if you think that the use of the 10% plan is itself either, certainly it's race consciousness, but really comes close to racial categorization, right? So that way it counts when you think about the actual numbers, right? So you're right, you can't look at it in isolation. But if the question is, look, in what ways have we limited the categorization of individuals, right? If that's our goal, if the jurisprudence goal is to say, hey, use race only in a very limited way and categorize individuals in a fairly limited way, then it seems to me that this plan does it, and it does it extremely well, all right? And so that, I think, if Kennedy strikes this down, it would seem to me that the answer is, yes, I am theoretically committed to race, to diversity from a constitutional perspective, but practically, not really.
Yeah. Okay. Well, let's hear from you folks. You've got to have questions about this. Yeah.
It seems to be that the consensus between both of you is that the grounds of this decision are going to be distinguishing it from the previous decisions rather than going back to those. But those decisions, a lot of them included an escape valve in the form of sunset provisions. So I'm wondering if you all think maybe that's going to play some role in whatever the majority opinion is or plurality opinion. Are they going to acknowledge that and backtrack on it, or the dissent's going to rely on it? What role is that kind of thing going to play?
Very quick, just be quick, and then the Fifth Circuit clearly said, both it and the district lower court found that there's periodic reviews of these plans. So it included sunset provisioning as a marker of the law and said, look, there's periodic review as well as annual review. And those reviews are theoretically designed to reconsider whether race ought to be used and how effectively that's working. So if you think of that as factual findings, then one would say that satisfies that escape valve.
Who else? I warn you, I'll talk some more if you don't ask questions.
From what I understand, I think some people have suggested economic factors might be a good replacement for considering race. Is there any reason, can you tell us any reason why race should probably still be part of the equation?
Now, when you invoke economic factors, what's the objective? Is it the same objective in a different means, or is it a different objective?
I mean, I'm not invoking it, but...
No, but if one were, because I think it makes a lot of difference.
Right. The idea that you want economic diversity, you want to be able to counteract the privilege some people have just by their background.
Mm-hmm. I mean, because certainly you can have a plus factor, right, for socioeconomic disadvantage, and the Equal Protection Clause is going to be invisible to that. And the question is, do you use that as a complement to the use of race, or do you use it as a substitute? And if you use it as a substitute, is it because you have a different objective? You're concerned about socioeconomic disadvantage as opposed to racial and ethnic diversity? Or do you use it as a proxy for race? And if you use it as a proxy for race, it seems to me there are two considerations. One is it going to be a good proxy? And there are a lot more white folks in the country than there are right? African Americans, Latinos, Asians, it depends where you are. And so to what extent is race correlated with socioeconomic status, right? And how good a proxy will it be? The second question is this, and this is a really, really interesting one from the standpoint of theory, which is if you're using socioeconomics as a proxy for race, then you still have the same race-conscious objective. You're just going about it in a less readily apparent, cooler sort of way. And ditto with respect to the percent plan. These are not race-neutral plans. These are race-conscious plans. The primary objective is to have minimum academic standards met while admitting a racially and ethnically diverse class. Now, the conventional wisdom is that you have the conservatives on the court who are into color blindness and don't like it when government uses race, and you've got the liberals on the court who are color conscious and they want to allow government to use race for good purposes and not for bad purposes, but it's actually a lot more complicated than that. Justice Kennedy, I just told you, is signing off on very race-conscious forms of state action. A race-conscious attendance zone, how you carve up a school district, determines who goes to which schools. And if you have a heavily racially segregated district, you can carve it up in certain ways to produce segregated schools and in certain ways to produce integrated schools. And I don't think he would uphold. He said if you carve it up to increase integration, you don't even have to use strict scrutiny. Do you think he's going to apply strict scrutiny if they carve up the district to increase segregation? Listen to what Justice Scalia had to say in the Croson case, Richmond against Croson. This is a 1989 decision in which the court invalidated a 30% set-aside for minority contractors in Richmond, in the Richmond construction industry, and the court struck down the use of this set-aside, this quota. But this is what Justice Scalia said in his concurrence in the judgment. A state can, of course, act to undo the effects of past discrimination in many permissible ways that do not involve classification by race. In the particular field of state contracting, for example, it may adopt a preference for small businesses or even for new businesses, which would make it easier for those previously excluded by discrimination to enter the field. Such programs may well have racially disproportionate impact, but they are not based on race. He's distinguishing color blindness from racial classifications. Now, there are some committed race conservatives today who are attacking the percent plans, saying they're race conscious and there's a discriminatory purpose under a couple of cases called Washington v. Davis and Personnel Administrator against Feeney. But that's not where Justice Kennedy is, and it wasn't where Justice Scalia was in Croson. Now, will he eat these words or distinguish them when the percent plan or something else comes before the court? I mean, imagine in Fisher, they imposed a percent plan with the purpose of excluding African Americans and Latinos from admission to UT Austin. The court would strike it down 9-0 and apply strict scrutiny. And what this means is that for all the talk about colorblindness, for all the talk about the Equal Protection Clause protecting individuals, not groups, for all the talk about there being only one race here, it's American, which is what Justice Scalia said. In fact, a number of justices who aren't liberals are thinking in race-conscious ways. That in fact there's a significant difference between certain forms of race-conscious action that bring children together on the same school bench or keep them apart, that increase educational or economic opportunities for historically discriminated against groups, right, or continue to reinforce their exclusion. So the conventional wisdom is that we're all about classifications and colorblindness, but in fact this anti-subordination reasoning, this concern about government actions that reflect or reinforce historical inequality are very much part of the logic of even some of the committed conservatives on the court. Yes, William.
So if this goes down the way you think it will, and they sort of narrowly distinguish Grutter, is that going to encourage like a flood of further litigation? Is the court going to have to continue to grant cert on this pretty regularly in order to keep playing this game of pinball back and forth?
Well, I mean, yes, if the court strikes this down, I do think that we're going to have to figure out what the legal principle is. And it might even go back to the point of whether race conscious itself is constitutionally problematic, right? So I think everything then comes into play, and we're going to have to figure out what sorts of programs, especially in contexts in which you can't rely upon, say, racial segregation to achieve some level of whatever you think of as critical mass, right, before layering on top of that a race-conscious and racial classification affirmative action program. So there will certainly be a fair amount. And there's something else that we haven't talked about, which is, look, we're increasingly diverse as a country, right? And part of the question that a court may have to think about is whether, if to the extent that racial inequality persists with us, how willing will the court be to say, no, you can't do anything about that, except maybe in some limited circumstances, some levels of race consciousness, but using racial neutral means. So I think there will certainly be a lot of back and forth on if the court strikes us down, so that we could find out what is the constitutional equilibrium point, because I think there'll be pushback on both sides.
Yeah, and let me say a little more about why and again, I could be wrong, don't bet on it. Experts are wrong all the time about what the court is going to do. And how Kennedy responds to this case could very well change over the course. How a case looks at the cert stage and how it looks when you're deciding or writing the opinions can change. So I don't know what's going to happen. But I don't think I'm being unduly optimistic from the point of view of those who defend these programs to say that the court's not going to overrule Grutter. I don't think the court loves to overrule previous decisions explicitly. I don't think they love to do it in particularly controversial cases, particularly when the result would be attributable to a change in personnel or composition, replacing O'Connor with Alito. I don't think they love to do it relatively soon after a previous decision was rendered. I think these are, I just, and also you don't need to strike this down. Kennedy has means available to distinguish Grutter. This percent plan is not implicated in Grutter. You didn't have a substantial amount of racial and ethnic diversity being produced by the law school in Michigan before they ever used a racial classification. So for all those reasons, and here's another one, and this is speculative. Now, we just had a presidential election, and it's a very important presidential election in a lot of ways. It's an election in which African Americans and Latinos in this country broke overwhelmingly for the Democratic Party. And so in the wake of that, right, in the wake of all the hand-wringing and talk now about what, if anything, the Republican Party is going to have to do going forward to try and win national elections, do 5 Republican-appointed justices want to overrule and end all of affirmative action in higher education and be responsible for the resegregation?
Screaming on the other side. The
resegregation of higher education, in which the elite schools, which is where it matters most, are going to be populated overwhelmingly by whites and Asian Americans. I'm not defending this as an appropriate consideration, and I think for some justices it's completely inappropriate. But I have reason to think that Justice Kennedy thinks this way. He is publicly agonizing over the court's legitimacy in Planned Parenthood versus Casey, in which he's explaining why the court should not overrule Roe. Chief Justice Roberts, in interviews, has talked about the court's legitimacy and concerns about it as an appropriate dimension of judicial role. So again, not defending it, but that's another conversation. But it wouldn't surprise me if this makes it at least marginally less likely that the court is going to move aggressively here to overrule Grutter, overrule Bakke, and say we are done.
And also, this case was litigated within the terms of Grutter, and even the
parties are not asking for it.
Yeah, the parties aren't asking for it, and they were making their arguments within the terms of Grutter. Breyer pushed on this, so it would be a bit surprising to see the court go outside of those terms, given the way that the case was litigated.
Right. And I don't think it'll be surprising to hear even some of the conservatives on the court talking about the virtues of racial and ethnic diversity and the appropriate or permissible ways in which governments may pursue that. I think you're going to hear that from Kennedy. Whether you hear it from Roberts or the others, I don't know. You didn't hear that in Parents Involved. Yeah, Christy.
So if it was actually struck down, even on the narrow grounds that you are cautiously predicting, what do you think the actual impact would be for schools? I mean, and where would it be felt? And
it depends what they say. right? I mean, if you have Kennedy writing the decisive opinion, and he's saying, I'm not saying you have to use percent plans or neutral means, but if you choose to do so, then you're really limited or may not be able to use racial classifications. That, for the time being, might not have much impact at all. But if he's saying you've really got to use race-neutral means first, and the classifications are strongly discouraged, I think that would have a very significant impact. I don't think that would be, I mean, that's narrow relative to overruling Grutter, but that's not narrow. I mean, what is Duke University supposed to do if it cares about having meaningful numbers of racial and ethnic minorities in the class that aren't being naturally produced otherwise? If it can't use race or ethnicity as well as socioeconomics and all kinds of other things as relevant considerations, what exactly is it supposed to do? What race-neutral methods? There's no attendance zone, right? There's no percentage plan. What is there? And so I think really depending upon how the opinion is written will determine just how significant it will be. And I agree with Professor Charles that there's going to be, this is going to be an invitation to more litigation. I think that's part of the intent.
You also saw how Texas reacted to Grutter and Hopwood. So, for example, with Texas going and conducting a study, right, of diversity within its classrooms and providing that as data to say, look, our problem is that in the classes the small classes that matter, you have 1 to 0 African Americans, Asian Americans, and Latino Americans. We've moved beyond a very different world. Latinos, we assume they're all Americans. Everybody. In the second context, the Texas going and conducting a study and saying, look, in the majors that matter, we've essentially taken folks of color and we've clumped them in sort of our less, to pardon the term, but less prestigious majors, right? In the other majors, in the other schools, we don't have very many folks of color in, say, the business school, right? So one response might be that institutions go and they conduct extensive studies and they talk to their donors and they show that, look, we've become a pariah as a consequence of a failure to, all right? So it seems to me that if the court says race neutral means first, then many institutions, not all of them, some of them will say, hands are tied, nothing that we can do about it, move on. But others who really care about this will probably go down this empirical route and try to create a record and then go back to the court and to say, look, here's the record of what we've attempted to achieve, and we can't without using some racial categorization.
Well, I should add that I think the part of what Texas is doing here is talking about not just diversity of the class as a whole, but diversity at the classroom level. And I think that's making the 5 conservatives very nervous. I think 4 of them will tee off on this. And I think Kennedy, if you read the transcript of oral argument, he just blurted out at one point in response to Greg Garr, former Solicitor General for George W. Bush, who's defending the Texas plan, Texas's counsel. So what you're saying is race matters above all else. And it was a non sequitur, but it tells you where he's coming from and how he's thinking about this. And so I think he's going to be very nervous that if you're doing this at the classroom level, seminar by seminar, now you're talking about using race a whole lot more than even, in his view, Powell was talking about. If it's not just the class as a whole, but classroom by classroom, you're going to have to take race and ethnicity much more into account. And I think that's, that makes this program more vulnerable in his eyes, not less. Yeah.
I am curious about more explicit race categorization, but not necessarily in admission. So, for example, in recruitment, is there any problem with that constitutionally?
It's such a great question. Do you want to take it?
Right. You're saying it's a hard question, so I'll start. Professor Siegel will bat cleanup. Okay, so yeah, I mean, I think recruitment presents an interesting problem, right? Because it's a combination of both, right? So it is saying, okay, yes, we are going to try to use at one level a race conscious, a race neutral mechanism, but it really is race conscious, and it is as well, you could say, particularly racially targeting, right? And it's also tricky because to the extent that that's obviously the pipeline by which you bring people in, then folks who aren't targeted, say, let's just assume for crude racial reasons here, let's just say white people who aren't targeted may then be less likely to apply, for example, and obviously less likely to be admitted, and if particularly what you care about are these opportunities. So now I think as a doctrinal matter, at least this is the way that I would read the doctrine, as a doctrinal matter, the race moderates on the court have often said you can do things like recruiting and selective citing and racial outreach, which is what Texas did, for example, post Hopwood. So they did these extra types of things to reach out to communities of color. So I think doctrinally, it seems to me that that it's not constitutionally problematic. Theoretically, right, as if you were really following the logic of the doctrine, theoretically, I think it raises a constitutional question if you think that if you are a race conservative or race moderate.
Yeah, I think if you take colorblindness talk seriously, it's unconstitutional. If you talk about racial classifications triggering strict scrutiny, it's unconstitutional depending on how it's done. It could be done in terms of we're going to focus more on this city in our recruitment efforts, that's general and indirect. Or it could be that we're going to focus on these particular individuals admitted in the class to try and recruit them and not these individuals. Those are racial classifications, right? I think Professor Charles is right that you're not going to have anything close to a majority to strike that kind of stuff down. And it tells you very interesting things. It's not just about color blindness or classifications. It's about certain kinds of classifications. That recruitment is regarded by many folks as different than who actually gets a spot in the class because of the scarcity, the perceived scarcity. Right? That I think it speaks to the court's concerns about hostility and balkanization. That it's more balkanizing, or it leads to more of a politics of racial hostility if you focus on who gets in versus recruiting people who've already gotten in without taking race into account. And so it shows you how what's actually animating the court is is not as simple as color blindness or anti-classification talk. And let me just, before we leave, let me just switch gears and think about, this idea of what a racial classification is. It's not self-defining, right? If race is being used as a factor, as a plus factor, why is that necessarily a racial classification that triggers strict scrutiny? What about the use of race in criminal suspect description? 5'8", white male, carrying a red knapsack, 6'2", African-American male, dressed in all black. Do you think the conservatives on the court are going to say, I mean, if it's using, race is one of several factors. If race is plucked in admissions as a classification, why isn't that? And yet, do you think they're going to say that's a racial classification that triggers strict scrutiny? Lower courts have not done that. They found it unimaginable. The Supreme Court hasn't addressed it. So what qualifies as a racial classification? And even among things that qualify as racial classifications, which ones are the courts going to apply strict scrutiny to and be nervous about? I think these are contextual and they're historically constructed. There's nothing inherent or conceptual about it. These judgments are made for particular reasons in particular contexts.
Your use of that example reminds me of, and I'm sure some of you have seen this, where you see the news bulletin of a suspect and you get 5'10" male. I'm like, 5'10" male? Give me more, give me more. How am I supposed to know? That's like the whole male population, right? Average male height, right?
Excluding this panel.
For sure, right? So there's a moral ambivalence, right? And I think that's part of what's interesting about this stuff is the moral ambivalence that it introduces at various levels.
All right, well, I think we are out of time.
Produced by Duke University, online at duke.edu.